was corrupted. It is your allegation.
State 2014 corrupted, and even the selection process were.
Paragraph does not say so.
Yes.
Paragraph says that it is state 2014 corrupted.
And then followed by, if I may, followed by they say, yes, once again, Milord, kindly come to paragraph 11. Several non-trained candidates were appointed.
Yes.
Now, the Lordship will go by the principles of a deemed pleading. I shall satisfy from authorities that the court, whose duty is to, Lord, find out the truth, should not strictly confine to the words of the pleading, but they have to also consider the deemed pleading. Here, pleading is categorical. Apart from 2014, where CBI investigation is going on, I shall also place the CBI chart sheet. Even in case of selection, non-trained candidates were appointed. Then paragraph 12. About example given to Mr. Y. Now, this Y is relating to recruitment in 2016 selection process.
So if it is to be deemed that the 2016 process was also under, then where is the prayer to that effect?
Yes. Now, may I place little more?
Just a question.
Yes, Lord, kindly come. Let us come to the prayer of the repeat. No, it's better to satisfy the queries of the court first. Lord, kindly come to the prayers in detail. I to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from date 2014, including the date of recruitment. Then direct the authorities to treat the petitioners equally with non-trained candidates who have been recruited by the board after expiry of the relaxation period.
That we understand.
Then kindly come to Lord 4.
By giving the same benefit.
5 is important. To direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment.
TET 2014, you are qualified.
Sorry, Lord, I skipped Roman 4. To recruit the petitioners by giving them same benefit by which other non-trained candidates were recruited by the board following the rules dated 22nd March 2016 and appointment notification dated 26 September 2016.
So your challenge was that either give those persons or the similar benefit like the untrained, non-trained candidates were.
Okay. But my prayer is everybody is charged. To recruit the petitioners following the appointment notification dated 26 September 26, very important.
So what is the kindly address us that on the basis it seemed to us as it was argued that TET 2014 allegations are there, nothing to do with this election.
Yes.
And that they would be satisfied in the event they are given appointment like those non-trained in the remaining.
No, but my argument would be, it might be not hurt many, that when the court finds there is much institutional corruption, systematic fraud played, starting from 2014 to selection, then I shall develop that. Now, to maintain the purity of the system and keeping Article 14 and 16 in the mind, court will be not hesitant to set aside everything and do it afresh. Yes. Now, I am just to complete the paragraph 12. I have given the instance of Y, then 13. Your petitioner stated the candidate, namely Pulao Sarkar, was not empaneled Another candidate named Dhiraj Bandyopadhyay having roll number was not empaneled. Bishwajit Burman having roll number was not empaneled. But they were called by the department for verification of documents, and from sources, the petitioners came to know that they were working as primary teachers. Look, this is fundamentally attack on the entire selection process. Look, how these were dealt with by the affidavit, I shall place it. Then this paragraph 13 says there was huge illegality.
Paragraph
13. Though there was huge illegality in the whole selection procedure of, it should be TET, not 2014, selection process 16, and everything happened as per the wish of the board. And for this illegality, the candidates like the petitioners could not get appointment as primary teachers. So this relates to the selection.
Yes.
Then a serious allegation in paragraph 15. Your petitioner further states that on 30th April, so-and-so, I am not naming, made a statement before the media pointing irregularities in TET panel. Recently, a person lodged a complaint against one MLA of All India so-and-so. That MLA took crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of one another MLA was arrested. The Constitutional Court would definitely not go deep into it to do complete justice and uphold the constitutional principle. Then paragraph 16, your petitioner states that the TET 2014 examination is the biggest scam in West Bengal since 2011. Then Lordship may skip over paragraph 17. Your petitioner states that TET 2014 is the biggest scam of the education department so-and-so. MLA, MP, leaders of ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, petitioner came to know that roughly such and such amount was given for job in TET 2014. Well, a job cannot be taken. It is made an absolute fraud was committed by the West Bengal board by not publishing merit list in respect of, it should be without selection qualified candidates.
When you are reading this,
Without paragraph 18, last two lines.
yes. Merit list of TET 2014.
Well, 16, selection 6. Then kindly turn to Milord, paragraph 22. Milord, 22, Milord, last three lines. I am not reading the entire thing. Your petitioner states that the respondents and each of them acted illegally, arbitrarily, and unconstitutionally in appointing some candidates who did not even sat for TET 2014. Serious allegation. Now, from the cans which were admitted by the court, I have prepared a list only to show that how many rank jumping was there. I shall place that. I have given them the copy also. Now, in the background of this pleading of the writ petition, now kindly takes up the affidavit filed by the board. That is in Milord, volume 2. at page 359. Now, that I would make this submission, probably it might be repetition, that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3. I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Then based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records, it is apparent that the aptitude tests were held. He wants to draw an inference on the basis of what? Since marks were allotted. Then paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, we're pleased to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. Then the interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, Milord, clearly admits then kindly come to 363, another affidavit by the President. Here, my lord, he describes from several authorities what aptitude test mean. I'm kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12.
It's 325. The 375.
The second direction contained in the order dated 24th of January 2023, passed by this Honorable Court, directs me to submit the list of interviewers at page 375.
I'm just wanting to see the 24th January order.
Yes, 24th January order, Malat, he was directed to file affidavit explaining the situation. 24th January order.
Yes.
The page 423, I am thankful to my friends.
Yes, Mr.
Yes. But the order says In course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test, there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165. Oath to 7 of such candidates being so and so, this is the order.
Yes.
Yes.
Now you are showing us para 12.
Yes. The second direction contained in the order dated so and so, Pathways Court directs me to submit the list of interviewers who interviewed, took the aptitude test so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview vivabocy aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took vivabocy aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no methodology was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmakar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to page 389, paragraph 9 of the, sorry, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in writ petition. Now, this is an admission that they did not do so. They say that we have not been done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 14, 16, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks for candidates who were recommended from the 2016 recruitment process.
2022.
And that too, my lord, in terms of order dated 2022. And that's not the complete list.